We want to write clearly and concisely so that our very busy readers, like judges or clients, can make decisions based on our writing. Choose your words precisely. As a lawyer, we are the master of words, and we need to use our words precisely. Adults learn better from visual images plus reading than from reading alone. Hence, the more visually appealing a text document is, the more engaged readers will be, and the more information they will retain.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Kathleen Dillon-Narco. Professor Kathleen Dillon-Narco is a clinical professor of law at Northwestern University Pritzker School of Law. She has taught legal writing since 1999, and her legal writing columns appear in the Chicago Bar Association's flagship publication, the CBA Record. Professor Narco has over 25 years of experience teaching a variety of legal writing courses, including communication and legal reasoning for first-year students, common law reasoning for international LLM students, and advanced legal writing for upper-class law students. The webinar presentation that you're about to watch will be approximately 1 hour, and Kathleen will be taking questions from the audience, time permitting, at the end of the presentation. So if you have questions that you'd like to submit, you can always do so by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Kathleen to discuss the power of plain language, say less, win more, part 2.
Thank you, Nina. And thank you, everyone, for joining today. Okay, so good afternoon, everyone. Again, my name is Kathleen Dillon-Narco. And as Nina said, I'm a professor at Northwestern Pritzker School of Law in Chicago. And I'm excited to continue our training sessions on plain language. This is part 2 of the webinar. For those of you joining me live today, part 1 came out last week. And thank you all for my returning viewers. I am glad you found part 1 useful and are ready for more. So thank you all for joining me today, and I hope you find lots of helpful tips to improve your writing. If you have any questions after today's session, feel free to send me an email. My address is here in the materials. And speaking of materials, as Nina said, they are available to you. I have included a number of columns I've written for the CBA Record, the flagship publication of the Chicago Bar Association. So without further ado, let's move on. These are the 6 topics that we are covering in both parts of the webinar. And we covered the first 2 and part of the third topic in part 1. We'll cover the remaining parts today. I will also provide a recap of what is in part 1, so you can be sure to look it up. So in part 1, we covered plain language, what it is, why you should use it, and how to write in plain language. We also covered concision, eliminating clutter from your sentences. Writing concisely is important to help your readers understand. And then in part 2, the last thing we started and the end of part 1 was clarity. In part 2, we will complete our discussion of clarity. Then we will move on to document design, advanced strategies in editing and organization, and finally, language change and how to write clearly with the singular they or other inclusive pronouns. So I'll do a little recap of what we covered in part 1, and then we'll move on to the meat of the presentation in part 2. So in part 1, we talked about plain language. And here is one definition of plain language. a form of English that can be read and understood by the typical non-lawyer. We are focusing on legal writing today, and our focus will be to write for your audience. And often that audience includes non-lawyers, whether it's a client or someone else that you are writing to, perhaps lay readers. We will address the best way to get our message across to non-lawyers. And we will see that even lawyers and judges prefer plain language. So the great thing is that if we write in plain language, we're writing in a form that non-lawyers and lawyers alike prefer. We talked about what is plain language, why should we use it, and how to write in plain language. We also discussed studies showing judges overwhelmingly preferred plain language. We covered the financial benefits to companies that use plain language in their agreements and communications. And then we talked about how to write in plain language, and that is really keeping your writing audience focused. And I included this chart of 8 ways to convert your document to plain language that basically breaks down into concision, clarity, and document design. Now, just a reminder, good legal writing is best understood as writing that helps actors make decisions in the course of their professional duties. It is a specific genre where we have very busy readers who have to make decisions quickly. This is not fiction writing. It's not popular press. It's not reading for pleasure. It has a function, and we want to write clearly and concisely so that our very busy readers, like judges or clients, can make decisions based on our writing. And just a recap of what we covered in concision, we talked about eliminating empty phrases, avoiding nominalizations, and simplifying words. The audience rewrote many sentences and phrases to make them more concise. We will continue that in a few minutes when trying to make our sentences clearer. So you might want to pull out a blank sheet of paper or open a new Word document to get ready for that. So now we are moving on to clarity, which is easing the burden on your audience. In part 1, we talked about subject, verb, object construction and how to identify those parts of speech. And the flip side of that, avoiding passive voice, unless it falls into one of 3 exceptions. And today we will start off talking about preferring concrete subjects, choose your words precisely, and shorten your sentences. So let's start with preferring concrete subjects. The problem is that a concrete subject is a real person or thing that your audience can visualize, while an abstract subject is an intangible concept or idea. So the problem is when a writer begins a sentence with an abstract subject, she hides who is doing what. And the solution? Put a tangible who or what in the subject position. So let's start off with one of our examples. Identify the abstract subject in this sentence and rewrite with a concrete subject. Increased production speed by the new conveyor belt is a competitive advantage that produced economic value for the company. Okay, I hope you all identified the abstract subject and tried to rewrite it. So first, let's look at this possible revision. We've changed the abstract subject from speed to focus on the belt, the conveyor belt. So the company's new conveyor belt increased production speed and gave plaintiff an economically valuable competitive edge. So we've changed from an abstract subject, speed, to a concrete subject. And that makes it clearer for our reader. Here's another example. Circle the abstract subject and rewrite. First, I'll show you the abstract subject is support. What is support? We can't touch, see, or smell that, or taste it. So we want to turn it into a concrete subject or something that we can perceive with our senses. So we change support to testators. We focus on the people. The testators showed charitable intent by donating to several charities. And just a word about some of these revisions that you'll see. You may have slight variations on them, and that's okay. No two of us are going to revise a sentence exactly the same way, but try to keep in mind the main focus of the exercise and see if you identified the subject and changed it to a more concrete subject. Clarity lesson number 3, be precise in your word choice. So choose your words precisely. As lawyers, we communicate most often in writing. Our profession is one that particularly values precise word choice. How much litigation focuses on the meaning of an unclear or vague term in a statute or contract? So here are some examples. Use the precise word for what you mean. Do you mean appraise, to value, or apprise, to inform? Do you mean averse, a negative reaction, or adverse, opposing? Do you mean contest, to challenge, or contend, to argue or allege? And take a moment now to look at the last 5 pairs of words and jot down what the precise meaning is of each of these words. So, do you mean disinterested, impartial, or uninterested, which means bored? So, we hope our judge is disinterested and not uninterested. Do you mean found, which refers to facts, or held, law applied to facts? This is a common one that lawyers even get wrong. Make the distinction between findings of facts and the holding, which is the law applied to facts. Do you mean means, meaning complete, or includes part of meaning expressed? We've we're all familiar with the phrase this includes, but it's not limited to. Do we need principal with the LE, which is a tenant, or principal, AL, the main thing, or a person? And for regardless, that is a word. And irregardless, I used to say not a word, although now it is in the dictionary because use is meaning, and so many people use irregardless. It is now in the dictionary, but it is still denoted as non-standard English. So please do not use irregardless. So here is an example. We have two sentences here. Circle the poor word choice and suggest alternatives. So in the first sentence, we have executed, the firm executed several steps. Do we mean took? Would that be better? Are the following details of the employee are significant? It's an imprecise meaning. Perhaps we mean characteristics or life. So choose your words precisely. As a lawyer, we are the master of words, and we need to use our words precisely and write clearly. So clarity lesson number 4 is shorten your sentences. So what is wrong here? The problem is lengthy sentence usually merge several different ideas, confuse logical relationships, and strain the reader's memory. The solution is to keep most of your sentences to 25 words or less and limit most to one main idea. Now, please look at the article in your materials, a column I wrote called Sentences Short and Sweet, that really looks at not only the length of sentences, but the issue of sentence clarity being the number of ideas. In the article, I give examples of how to identify how many ideas you have in one sentence. You can also identify and eliminate excessive prepositional phrases. So here's what the experts say of between 20 and 25 words is a good average sentence length. So Richard Wydick, in his wonderful book, Plain English for Lawyers, says 25, about 22 from Enquist and Oates, and about 20 from Brian Garner. So I'm not saying that sentences have to be at the elementary school level. This is not C-spot run. 25 words or 20 words is a long sentence, and this is the average. You may have some sentences that are short, that are 3 or 5 words, but vary your sentence length for your reader and try not to have sentences that are too long. And I will add one other note about sentence length. Some of it may have to do with either your background language or your writing habits. So I have had students whose native language is not English, and they tell me that, well, in my language, we write these long, beautiful sentences. So we're not used to writing these short sentences. So if that is your case, maybe that's something you can identify in your writing and actually count the words as an average sentence length. I've also had native English speakers who just have the habit of writing in long sentences, so much so that they cannot hear it. And I put air quotes around that. When they read over their writing, the sentences sound perfectly fine to them because they're used to writing that way. So, what you may need is some mechanical way to identify what your average sentence length is. So, if you have Microsoft Word 365, you can find out your average sentence length by following these directions. It will show you a readability statistics box, which includes the average sentence length. So just a note, be sure to go through all the grammar and clarity suggested corrections. If you do not correct or ignore all of them, you will not see the readability statistics box. But I ran the readability statistics of one of my recent columns for the CBA record, and the average words per sentence was 16.6. So apparently, I like shorter sentences. I think they're a little bit easier to read. And here is someone else who likes shorter sentences. Someone who would have been a great model for legal writing, Ernest Hemingway. This is from a short story he wrote, Hills Like White Elephants. And when you read through it, the sentences are short, direct, declarative sentences, but they still set the scene. The woman brought 2 glasses of beer and 2 felt pads. She put the felt pads and the beer glass on the table and looked at the man and the girl. The girl was looking off at the line of hills. They were white in the sun, and the country was brown and dry. They looked like white elephants, she said. So we still feel the tension of the scene. We're brought in through the server who puts the beer glass down on the table, and we feel the environment. And that's only 12.2 words per sentence average. So Hemingway was a journalist as well as a novelist, and you can see that in his writing, short declarative sentences. Compare that to another fiction writer, Virginia Woolf. This is a sentence from To the Lighthouse, and see how far you can get before you run out of breath. Apart from the habit of exaggeration, which they had from her, and from the implication, which was true, that she asked too many people to stay, and I've run out of breath. Look at all these phrases in here. Had to lodge some in town. She could not bear incivility to her guests, to young men in particular, who was poor as church mice. And it goes on, 66 words. So, great novelist, not a great model for legal writing. I will say I got used to the way Virginia Woolf wrote, and it didn't bother me so much when as farther I got into the book. But we don't want to assume that a judge reading our brief is going to give us that much time to get used to our long sentences and writing style. We want to make it very easy for the reader. So read this sentence, rewrite it, and you may have to divide it into 2 sentences. Okay, here's one way you might rewrite it. Divide one long sentence into 2 shorter sentences and start with the most important points for your client. The parents did not neglect their son. We also eliminated an opening empty phrase, which was from part 1. We talked about empty phrases, which in this case was, as we have already explained. No need, it adds no meaning to the sentence, so just cut it. And follow the subject, verb, object structure in the first sentence. So we have parents did not neglect their son, subject, verb, object. Another point we discussed in part 1 of this webinar. Now we are moving on to document design. This is a practical way to change your document to plain language. You might think with design, document design, how does that relate to what I write? Well, here, Gerald Leibovitz, who is a state court judge in New York, says how a document looks is as important as what it says. And that is a provocative statement, especially for us lawyers who pride ourselves on being good writers, but we don't normally think about graphic design. And, that's not why we went to law school. But in your materials, I have an article about document design that goes into more detail on all of what we'll go over in a few minutes. So this is a quote from the Seventh Circuit's Handbook for Appeals. And the Seventh Circuit is ahead of the curve. It has issued requirements and suggestions for typography in briefs or other papers. Typography is another name for document design. And you can find the entire handbook on the court's website. If you need that link, just email me and I can send it to you. But this quote is very telling. This is written by the court. Reading up to 1,000 pages per argument session is a chore. Remembering it is even harder. You can improve your chances by making your briefs typographically superior. It won't make your arguments better, but it will ensure that judges grasp and retain your points with less struggle. That's a valuable advantage which you should seize. So this is the Court of Appeals for the Seventh Circuit telling you that document design matters. It makes it easier on the reader, makes it easier for the judges to grasp and retain your points and remember it. And the Seventh Circuit encourages you to consider good document design. And again, Judge Leibovitz talks about typography and what that includes: typeface, type size, word space, margins. We'll go over some of these, but again, look at my article for more details. And Matthew Butterick, a graphic artist turned lawyer, defines typography as the visual component of the written word. This includes things that affect how text appears on the page, like font type, white space, alignment or justification, underlining, italics, and more. When done with an eye towards better design, all of these factors come together to engage readers and keep their attention. So without effective, legible typography, the reader won't appreciate a document's content. When you have a choice, make the document accessible, comprehensible, persuasive, and professional. So this really tells you why typography is important. Good document design makes it easier for the reader to read your writing. This is another opportunity to engage the reader. Don't miss it. And also, science supports the court's emphasis on good typography. Educators and psychologists have studied how adults learn best for over a century, and adults learn better from visual images plus reading than from reading alone. Hence, the more visually appealing a text document is, the more engaged readers will be, and the more information they will retain, excuse me. So let's go into some of the details. Typeface or font choice. Always use proportional fonts unless required to use monospace by rule. And you see the monospace has the same amount of space for each letter. The origin is typewriters, when every letter had to take up the same amount of space. A capital W took up the same amount of space as a lowercase I. But now with word processing, we have proportional spacing. As you'll see in the second word, the lowercase I takes up less space than an O or the P. In the second line, we have serif or sans serif fonts. The serif on the left has a little tail at the base of each letter. And what scientists have learned and what educators have learned and graphic designers is this little foot, the tail, helps move the reader along the line. This makes them easier to read for large blocks of text. And sans serif fonts have no tails. They may be easier to read on electronic documents, but you may want to use sans serif for headings and then the rest of the documents in serif fonts. And some experts in typography suggest law firms should hire a graphic designer for an important brief or use a special font designed for legal documents. And that may sound outlandish at first blush, but think about all the other outside consultants law firms hire for jury trials or experts or someone to do the exhibits. So think about this as well. Any edge that you have to be more persuasive, you can't take it too lightly. So the next area is justification of text. Do we want left, right, centered, or both? So this justification is also called alignment and refers to lining up text with the vertical line on the page. So in the left example, we have left alignment only. The middle is centered. And the far right example is both sides are justified or fully justified, is lined up both the left and the right side. So some people like this fully justified look, but the Seventh Circuit specifically says that you should avoid it because full justification, especially if you use monospace type, leads to odd spacing between the letters and the words. The text in full justification is forced to the left and right-hand side of the page, and it makes the words appear stretched, and it will appear to slide down the page. Also, it creates strange spacing between words. I think you see that in the far right example, and line up a few of those together, and you get what's called rivers of white space moving down the page. So this can make your document also difficult to read. And for for me as a professor, it also wreaks havoc on citation format because it's unclear whether the spaces and punctuation in citations are correct. So legal writers should stick to the far left version, which is only left aligned text. It is the easiest to read. The right hand, which is called the ragged edge, helps readers find the beginning of the next line, and it helps readers keep on reading. It shows them where the end of the line is and then tells them to go to the next line. So avoid using more than one text alignment, except maybe you could use centered for headings and for section. So white space should be 50% of the page. That is a rule from graphic design that graphic designers use to keep the reader's attention. So we should take the advantage of the lessons from the discipline of graphic design. It helps the readers, white space helps the readers focus on the text. It makes the text stand out. And white space lets readers rest after reading the text. It breaks the monotony. And it gives readers information in bite-sized bits to enable readers to digest the information, says Gerald Leibfitz. And here here I've listed a number of ways that you can maximize white space, such as having wider margins, shorter paragraphs, add more headings, add a blank line between sections, use bullet points and numbered lists. Tabulations can really help if you have a lot of items in a sentence. And use the left justified margins and avoid block quotes if you can. So document design is just another way to make it easier on your reader. It can be another way to persuade your reader. And it is another aspect of plain language. Another part of document design is use only one space after punctuation. I know I was a holdout on this one too. Many attorneys who learned to type in a certain era have muscle memory of two spaces after a period at the end of a sentence. But for typewriters, two spaces were necessary to see the end of the sentence in the days of monospace fonts and typewriters with word processing and proportionally spaced fonts. However, use of two spaces creates a wide white space after each sentence. And string a few of these together, you have rivers of white space in your document, which, in the words of the Seventh Circuit, interfere with the eyes moving from one word to the next. So the rivers can slow down your reader. So for those of you who are used to putting those two spaces in, think about why we did that at the beginning. It was because we had to with typewriters, and we really don't need it anymore. So consider moving to one space after punctuation at the end of a sentence. Now, I cannot leave talking about document design without passing along this caveat, which is always follow court rules or organizational style guidelines. in the article that I wrote on document design, which I've included in your materials, is this important caveat: always follow court rules. I received an email from a local attorney in Chicago who changed the margins and appearance of his brief to follow my recommendations in the article. Unfortunately, he forgot to check if the brief was still within the page limits. His revised brief exceeded the page limits and was rejected. Unfortunately for him, he was able to explain to the judge why he had made the changes and was able to file a new conforming brief. So always check the court rules before changing your margins or font choice or any other document design suggestion. So although a 1.25 or 1.5 inch margin will make your document more readable, you may not have the options to use those settings. If a court mandates 1-inch margins, you must follow that rule. Otherwise, you risk harming your client by filing a non-conforming brief. So not all courts are as cognizant of document design as the Seventh Circuit. So now we're moving on to good legal writing is also engaging and elegant. So engaging, we vary sentence structure, voice, ability to tell a compelling story, pathos, and proper tone. So here's an example from a Supreme Court brief from 1956, actually, but it's still relevant. And Richard Newman, a professor, included this in his excellent text on legal writing. The animals were rounded up on the range and were either driven or hauled in trucks to a government-owned or controlled corral 45 miles away. Horses which could not be so handled were shot and killed by the government's agents on the spot. The horses were so jammed together in the trucks that some died as a result, and in one instance, the leg of a horse that inconveniently protruded through the truck body was sawed off. So this is an example of using pathos or emotion and vivid imagery to engage the reader, and yet none of it is an overstatement or objectionable. When we think about elegance, we think about an aesthetic quality. It's found in great briefs and judicial opinions. So is it necessary in good legal writing? So for most of our daily emails and short communications, probably not. But it is important to know how to rise to the occasion when you draft an important opinion or other important communication. It's always good to keep our quality of writing high and try to follow the principles we have gone over today and in the first training whenever you write. Be known as the good writer in your office. Now I'm going to move on to some strategies on organization and later editing. And you have a handout in your materials entitled TRIAC, the New IRAC, or Why Organization Matters. So if you have any questions about what we're going to go over, you can read that handout and then go over these slides, but feel free to ask me any questions or send an email. So TRIAC is a variation on IRAC that we used in law schools: issue, rule, application, conclusion. And we have the acronym TRIAC. What does it stand for? Topic, sentence, rule, explanation of the case law, application, which also includes plausible counterarguments, and conclusions. And when I first published this column, my inbox was flooded with comments from attorneys who had given it to their junior associates or students and even paralegals, or how to organize legal analysis of a single legal issue. So we have the sample issue in the TRIAC article that the franchisee allegedly used racial insults against an African American customer. So the plaintiff has alleged, among other arguments, that an apparent agency relationship existed between the franchisor, company ABC, and the franchisee, Joseph Smith, and the author represents ABC. So we have a topic sentence, a declarative sentence stating the conclusion on a given issue. So in this example, it tells the answer. There was no apparent agency relationship between company ABC and Joseph Smith. So you tell the reader your legal conclusion. Don't bury the lead. In the rule, we set forth a general rule, applicable regulation or law. In this case, there was a 3-factor test from a state Supreme Court decision. It was binding authority in the state where the controversy took place. One sentence long, direct quotation generally works well. We have the explanation of any decisions discussing that rule. We include the facts, reasoning, holding the relevant case law, usually 2, maybe 3 cases, and end with the synthesized rule that refines the general rule. So in the apparent agency hypothetical, a state Supreme Court decision held that mere use of the franchisor's products and logo did not create an agency relationship. And this holding expanded upon the 3 general factors the court examined in order to find agency relationship and was relevant to the company's decision, to the company's case. So we have common errors in the explanation, are incomplete or misleading facts, inadequate discussion of the court's reasoning. That's a big one. In the application, we are applying the law to the facts of our case, and we analogize and distinguish from the applicable decisions. We compare the facts of the decision directly to the facts of your case. This is especially important if it is a fact-based distinction. And the common errors are stating that your case is like another without explaining why, failure to include significant facts. And finally, we come to a conclusion. Always come to a conclusion and state that clearly for your reader. This is a mistake that junior attorneys or law students frequently make. They merely state the arguments on both sides without stating a clear final conclusion. And I have to remind them that the supervising attorneys are relying on them, that they are performing their job and reaching a conclusion. And here we have a sample conclusion. In the TRIAC example, you see there are two parts. The first is the legal conclusion, no apparent agency. And then second is an action step. Therefore, the court should grant ABC's motion for summary judgment. So be flexible in applying TRIAC, depending on how complex your issues are. Next, we have advanced strategies in editing, writing the lead to your memo or brief, omit the preliminary information, and draft the introductory paragraph summarizing your key issues. We had an example of that in part 1. Move from the long classic traditional introduction to just say what your motion is about and why you should prevail. Remember about editing that it is as crucial to the final product as the draft itself. Many lawyers miss this point. They think they're done as soon as they finish the draft. This is not your best writing. So edit once for each of the following: transitions, proofreading, concision that we covered. Have you applied the rules? Clarity, have you applied all those? All those examples, citation, and checklists. I recommend Joe Kimball's book, where he has checklists on writing both memos and briefs. And now I'd like to address a little bit about language change. So, should we follow traditional rules of grammars, such as no split infinitives, or using they instead of he or she? And this article that I've included in your materials was written over 10 years ago, and it was just beginning to change. I interviewed 3 judges from the Seventh Circuit, Judge Diane Wood, Judge Rovner, and Judge Posner. And Judge Wood followed the most traditional rules of grammar and was not ready to accept the singular they. Judge Rovner was kind of in the middle, and Judge Posner was the most liberal as far as grammar goes. He focused on understanding instead of following rules of grammar. And at that time, I urged readers to follow rules of grammar because you never know who your judge might be. But things have really changed since then. The singular use of they has been adopted in dictionaries and as the word of the year. And we have also seen the use of they for people who do not prefer he or she. And I've included additional columns in your materials on the change in the use of inclusive pronouns, how to write clearly with inclusive pronouns. And here we have 5 tips on writing clearly with inclusive pronouns. There are more tips in my column in your materials that you can see. We've changed from noting it to advocating to follow people's choice. So the first rule is respect a person's chosen pronouns. And if you're not sure, ask. And many current style guidelines require you to use they if the person you're writing about asks you to. So you can always ask. And if you're writing to someone who is unfamiliar with that, such as a judge, you can explain why you are using they as a singular pronoun. But here are some other tips for writing clearly. You may repeat the gender silent noun, such as a person. I'm sorry. Here's an example. A person is entitled to the benefit if the person. So you can simply repeat that. And here you can change a shareholder to repeat the gender neutral noun, a shareholder in both instances. You can write in the plural if it is not ambiguous. Instead of a director shall be paid his or her reasonable expenses, change it to directors and their reasonable expenses. Rewrite to avoid gender references altogether. Here we have he or she. You could change it to a person and change the wording of the sentence. To avoid pronouns, replace the noun with the verb. Instead of his or her consent, you rewrite the sentence to use the verb consented. And our final topic today is writing well, worth the effort. So I've included a column on that, which was written a few years ago when John Roberts was still a nominee to the Supreme Court. And one of his colleagues wrote about how much he stressed good writing. So we talk about good writing. It improves your chances for professional advancement if you are a more junior attorney. And if you're more senior, then think about if you set the example of good writing, it will promote better writing at lower levels. And this brief really says it all, that your brief conveys not only your argument to the court, but it also conveys a sense of your credibility and the care with which you put your case together. So good writing is worth the effort. And I'll just go through these quickly. These are what we talked about in part 1. Writing concisely, writing clearly in part 1 and 2. And today, document design, advanced editing, and language change. And yes, writing well is worth the effort. So thank you all for coming today. And Nina, do we have any time for questions?
Yes, we have a few minutes for questions. Now, as Kathleen mentioned, we can go ahead and move on to those questions if anyone has any. It looks like we've already got quite a few questions, so we'll take a few, as many as we have time for. This first question is from Ashley. They ask, when using the singular they, should you then use other terms for multiples so as not to confuse, i.e. the parties, the plaintiffs, the witnesses, etc.? What do you recommend?
Well, I think those are two different questions. When you're using the singular they, you are referring to one person who prefers using they. And generally, when you're using plurals in other areas, that can make your writing more clear. I would say, yes, use the plurals if it makes sense in the sentence and the paragraph of your brief.
Wonderful. Thank you, Kathleen. All right, our next question is, if we already feel we've implemented the part 1 strategies, which part 2 techniques should we prioritize first for the biggest improvement?
Well, document design is one that people often overlook. So I would say take a look at that. That that something before you turn something in. Implement those. Other words for the part 2 strategies, I like shortening your sentences. So many people write long sentences and have long introductory phrases when they could be more direct to the point.
Thank you, Kathleen. And then I did see a couple questions about the materials. So you can download the materials via the webinar page. If you go ahead and visit that page, I'll go ahead and put the link in the chat. And then once you're logged in, there will be a button below the thumbnail where you can download those. Thank you. Our next question is, do you have any examples showing how combining clarity, concision, and design transforms a brief section? If so, where can we find them?
I don't have any examples offhand of a before and after of a complete brief, but that's a great idea. I should put one together. I think you could probably look in some of the books I've talked about, like Richard Wydick or Brian Garner, who have a lot of before and after examples, and might have something that would be similar to what you're looking for.
Thank you, Kathleen. Our next question and our last question I think we have time for is, how can I identify when my subject is too abstract or vague and then write it to be more concrete?
Well, the test of abstract subject is that it cannot be perceived with your senses. So if you can't taste, touch, hear, see, feel, I don't know if I covered all 5 of the senses there, but that is your test. If it's something you can see and hold, then it probably is concrete. If it is not something that you can perceive with your senses, that is just in your mind, then it's probably abstract.
Awesome. Thank you, Kathleen. That's a great rule of thumb, and we really appreciate your additional insights today. And thank you to all of our audience members that sent in questions. We're going to go ahead and wrap up for today. So thank you all so much again for attending another Justia webinar. Thank you all so much for your time, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.